Hi everyone, Derek Johnson with Tatango.com. I'm here at Innovista Law, home of the TCPA Defense Force. And I'm sitting with Joe Bowser, who's a TCPA attorney. And we're discussing how the TCPA affects text message marketing. So what we're going to discuss is how long do you need to keep text message marketing records to, I guess, make sure that, in the future, if there were a complaint against you or the brand, you're protected. Does the TCPA specifically say how long you need to keep records?
It doesn't say how long you need to keep your SMS records,
Okay.
but it does say how long you can get sued for making a call that might violate, or sending a text that might violate the law. And
Like in the future?
Exactly.
Okay.
So there's what's called a statute of limitations.
Okay.
Right. So that tells plaintiffs or people who want to sue under the law how long they have to bring up their grievance in court. So from the time of that message, they have 4 years to file their case.
Oh, wow. Okay.
So they can sit on it, and
So they get one text message, it was a violation, they can sit on that for 4 years and then sue based on that one text message 4 years ago.
exactly. So you should use that statute of limitations to tell you how long you should keep your consent and text message records.
Okay.
Right. So it should be at least 4 years, right?
Okay. Because you
And-
need the original consent to prove that they actually opted in.
Exactly.
Okay.
So right. So ideally, if that claim ever comes,
Yep.
you can prove both that you had the consent and you can prove how many messages you sent them.
Okay.
And when you sent them.
Okay.
And their relation, to the consent.
So essentially, it seems like you have to save everything. Like this is not just save the billboard advertisement that you used to get the consent. You have to save their opt-in message flow, every text message they've sent in, you've texted them. Really, everything should be saved.
Ideally. I mean, look, because at the end of the day, what you don't want to have happen is you have to go to trial over whether you sent 30 messages or the 60 they remember getting.
Okay.
Right?
And it makes it easy then if you have a record of every single interaction you've had with this customer. So then you could see when they opted in, what messages they received, whether they applied stop or help, the whole interaction, I guess.
Exactly. There are special evidentiary rules surrounding regularly kept business records.
Okay.
So if you regularly keep your call logs or your SMS logs, those things are going to be able to get admitted into evidence and treated as a regularly kept business record. And it's going to be very hard for the plaintiff, if he doesn't have his own call
Records.
logs
Yep.
to dispute that, to say that your records are inaccurate.
Yeah. So it really seems like almost any business that is doing text message marketing should really keep their records for 4+ years or just as long as they can.
As long as they can, right.
Yeah.
And as data gets cheaper,
Yeah.
the upside of keeping them longer
It's protecting yourself from TCPA litigation, or at least just knowing that you know how someone opted in and what consent they had. Now, would that be included, like if you run a television ad, should you keep the television ad? If you run a billboard, should you keep not the whole billboard, but like a copy of the billboard, like everything?
the ad copy. So long as that advertisement is related to how you got consent.
Okay.
Right? Because consent is a defense in the TCPA. So it's the defendant's, it's the sender's burden to prove that they had consent.
The brand, it's their responsibility to prove it.
Exactly.
Okay, so at the end of the day, they're the ones that have to come up with the information.
Right,
So
because
saving it is a good idea.
Right, because the plaintiff has walked into court and said, you sent me messages and I didn't consent to get them.
So then it would be
That's
the
all he has to
brand's-
say, essentially.
Brand saying, no, here's the evidence to make that not true, essentially.
Exactly. And typically in the day-to-day trenches, the plaintiff's attorney will typically send a demand letter.
Okay.
And you want to be able to very quickly gather those records, send it back to them, and say, go find your next target. Your
Because you have the record right here.
Client, right.
Every interaction with that client, here's the billboard, here's the text messages. If you don't have all that info, then it becomes just a nightmare, I'm guessing.
Well, when the plaintiff's attorney hears crickets
Yeah.
and doesn't get evidence of consent pretty quickly, you should assume you're going to get sued.
Okay. So no matter what SMS provider you're using, what type of campaign, always just keep your records, keep them for 4+ years, depending on kind of, I guess, when the person opted in and their last message. But essentially nowadays with data being so cheap, just store them forever.
Right.
Like 4 years after the end of the campaign, I guess you could say, right?
Right, because so the calls that are 4 years and older
Yep.
fall off. Now, filing the case, what's called tolls or suspends the statute of limitations. So the case can continue on, but
Yeah.
hopefully once you see the lawsuit, if you might have made an error, you fixed it.
Yeah.
But in any event, the statute of limitations gets told when you file the case, so you really get 4+.
4+.
But
okay.
you want to go backwards, like you said, to make
the
sure
opt-in.
to the opt-in, because the consent might have happened a year before the message when
That
he
they're claiming.
complains.
Yeah.
Oh, I went to the store and said, hey, Target or whoever,
Yeah.
stop texting me.
Yeah.
Right. So you've got to prove that you had his consent in the
And
first
that could
place.
be 5 years back from the 4 years here. So it seems like a good kind of rule of thumb is just keep the data.
Right.
and
Exactly.
and it's only text messaging data. It's not huge files or anything. It's only 160 characters.
Right.
So it shouldn't be that hard to keep.
Exactly.
Anything else that people should know about keeping text messaging data to reduce kind of the risk of TCPA compliance?
I mean, there are evidentiary issues around how you want to maintain the data.
Okay.
Because you want to be able to prove that it wasn't altered.
Okay.
Right. So you want to make sure that there's these so-called chain of custody issues, that the plaintiff can't poke holes at the reliability of your data.
Oh, interesting.
So you want to make sure that you have written procedures that your IT folks follow to make sure that the data is clean.
That's really smart. And that's something, too, you can collect all the data, but if it's not handled correctly, you're screwed in the end anyway. So
Exactly.
Okay, interesting.
Or you're prolonging the case needlessly.
just making it harder
Exactly.
on the brand.
Right. So
Wow.
clean data is the best data.
That sounds good. Again, I'm Derek Johnson with Tatango.com. We have Joe Bowser from Innovista Law and the TCPA Defense Force, and we were just talking about how long a brand should keep their data when it comes to text messaging and the TCPA. And the kind of overall consensus here is pretty much as long as you can, like in 4+ years, but really with data being so cheap nowadays, just keep it for forever essentially, because you never know when one of those cases will come out of the woodwork. Thanks for watching our video today. If you like this video, be sure to give us a thumbs up on YouTube. If you want to see more of these types of videos, be sure you subscribe to our YouTube channel. And if you have comments or questions, please leave a comment or question in the comment section below.